Hey guys, welcome from my public law class. I recorded this about 15 times. So sorry. This is as good as it's gonna get. Yeah, I'm just gonna jump right into it, right? One of the key persons points that I'd like to point out from the textbook in these chapters that really helps tie con law and admin law together is Chief Justice Earl Warren, right? And he presided in the Supreme Court from the times of 1953 to 1969. And one of the key reasons for me why he's so important is because he took the Bill of Rights, which was just a theoretical document at that point, and used the 14th Amendment to apply the Bill of Rights protections to the states. And what this meant was state and local governments were now bound by federal constitutional standards. And this increased the constitutional rights dramatically, right? We have our right to counsel, protection against self-incrimination, equal protection in education and voting. We see with some of the cases that they took on, Brown v. Board, which is vital in desegregation. We have Miranda v. Arizona, which again, self-incrimination, right to counsel. This was one of the most influential times for U.S. history, period, right? And even though the court is supposed to be apolitical, we see with the Warren Court how policies, historical context, even the Chief Justice leadership kind of shapes the way the court interprets laws, right? He believed in a living constitution approach. And again, that kind of meant that we weren't supposed to adhere to the Constitution as just a set of standards. He believed that the Constitution was meant to evolve as society changes as well. Again, hence why we had all these civil liberties that were granted to us under his leadership for the Supreme Court, right? And we also have, of course, Bill Madison to thank for even having the Bill of Rights, period. Bill Madison and the Anti-Federalists, right? They had the forethought that the Constitution created a centralized government. And with that, it wasn't an if, but it was more over when the government would overreach for their powers. But the framers didn't believe that that was even necessary, right? The federal government had enumerated powers. What wasn't written down kind of didn't exist. So they couldn't overstep what they didn't have in the first place. But they didn't foresee the expansion of the government, period. They didn't anticipate the superpower we would become globally. The amount of people that would then move in, the population, period, right? So they didn't have the forethought, but James Madison did. And through James Madison, we have him to thank for the Bill of Rights that then Chief Justice Earl Warren used, where it wasn't just a theoretical piece of document anymore, and it could actually be used to protect us. And the Bill of Rights is vital for, again, our rights. And one of the main things that I'd like to bring up is the executive powers that the executive branch has, right? Congress granted the ability to delegate because the government was just so big, they couldn't do it anymore. So they then granted agencies the ability to make laws, enforce laws, and adjudicate disputes as well. The problem with granting authorities this power is when you grant them the power, you can't easily take it away anymore, right? And they become permanent in our society. Courts defer to their expertise, and it creates an institutional permanence. You know, the systems and regulations that they create then become entrenched in society as well. And so the agencies remain, the authority remains, and even though the presidents are permanent, again, 4 to 8 year terms, most of the agencies are under the executive branch. And though the enforcement priorities may shift for who's head of executive branch, the power that they have still stays. It doesn't go away, right? And so the president, he has the power to appoint agency leadership. He is able to direct enforcement through executive orders, and he controls regulatory priorities. And though the executive branch is not able to make laws, this kind of gives them the indirect power to shape laws. We see that through the EPA, again, environmental regulations that they set. We see that through HHS and CDC with the public health authority that they have. One of the biggest ones right now, DHS, right, with immigration enforcement and national security. And again, the executive doesn't pass laws, but they're able to decide how aggressively laws are enforced, which priorities take precedent, and how broadly rules are interpreted. And this discretion is power. And then this creates this tension between the Bill of Rights becoming a key limit to their reach over people, and this is where the courts are often the only check to keep the executive power in place. And we see a lot of these conflicts arise where agencies' actions affect speech, privacy, and or due process as well. We see emergency powers expand the executive authority as well, and where national security is used to justify broad discretion. And again, this creates a tension between efficiency and liberty. And that is my takeaway from these chapters. All right, and hope to see you guys next week. Thank you.